Today's Blindside archives an interview with Karen Straughan on Irish radio station Limerick Live 95, where she talks about sexual assault law in Canada and Ireland. Karen is one of the most effective and well-known champions of equality and human rights for men in the entire world, and this interview was broadcast in the run-up to her keynote speech at a conference hosted by Men's Voices Ireland in November 2019. Further information about both Karen and Men's Voices Ireland can be found by following the links provided, which includes a link to a video of Karen's full speech from that conference.
This week often, people are accused of not saying enough about men's rights in this country and the world in general, that we're always defending women's rights. But there are organisations out there that do defend the rights of men and boys. Men's Voices Ireland is one of them, and they're holding a conference this weekend up in Dublin. Karen Straughan will be speaking at the conference about proposals to change the law in sexual assault cases, and she joins us on the programme this morning. Good morning to you, Karen.
Good morning to you. Thanks for having me.
Karen, you're a men's activist yourself, which is, I suppose, in some ways an unusual thing that as a woman you've chosen to speak out in favour of men's rights.
Well, I think it's kind of an unfortunate thing that people believe that that's unusual. It is unusual, but you wouldn't necessarily ask a man who isn't, calls himself a feminist or fights for women's issues or, does the charity run for breast cancer or whatever, well, why would you do that? You're a man. Of course, the reason why he's doing it is because he has women in his life that he cares about. He cares about women in general. He wants women to do well. So that's really, it's unfortunate that it seems so surprising to people that there are women who would come out, to bat, to go to bat for their fathers, their sons, their brothers, their husbands, and their male friends. So, yeah.
So tell me about the speaking that you're going to be doing at the conference. It's about the changes to the sexual assault laws. What is being proposed at this point?
Well, there are some. I'm not too familiar. I've done some digging about the changes to proposed changes to Irish law, reasonable person standard, instead of an honest and genuine but mistaken belief and consent, things like that. It really kind of boils down to how those are implemented. I think that everybody can sort of agree that a reasonable person standard, just on the face of it, is perfectly fine. That you can't just have people who walk around and sexually assault other people and say, well, I honestly believed, that they were consenting, when, no reasonable person would think that. But it really boils down to how those are implemented, what the restrictions and limitations are, and one of the other speakers is going to be getting deep into that. I am actually going to be talking, sort of giving a primer on what not to do. I'll be discussing a lot of the changes that were recently made to Canadian sexual assault law. And some of the aspects of those changes have already been ruled unconstitutional by two judges, as in they deprived the defendant of his charter right to a fair trial.
Can you give us an example?
The prime example in the recent changes is that, and I don't know how savvy on the law your listeners are, but in a criminal case, the complainant, the accuser, is not the client. They're not the plaintiff. They're not the client of the prosecutor. The prosecutor's client is the people or the Crown. And the complainant is just a witness to the case. As such, they are not a party to the case. They are entitled to no information, no disclosure from the defense, no disclosure from the prosecution. It's actually illegal in a criminal case in Canada for the prosecutor to disclose evidence to the complainant that the complainant doesn't already know, regardless of where that evidence comes from. And the complainant will not be allowed to be in the courtroom while others testify until they've given their own testimony, because they don't want the testimony to be tainted. But in rape shield hearings where certain pieces of evidence are argued over pre-trial as to whether they're admissible. Now in Canada, the complainant and her personal counsel that she's now entitled to,
sorry, just when
even
you
though she's
when
not
you
a
say
party to the case, they have standing in rape shield hearings. So she will be able to look at all of that evidence prior to trial, and that actually so it legally mandates the tainting of witness testimony. I'm amazed that it actually passed muster in Parliament and in the Senate, given how it stands the entire process on its head.
When you say the complainant, you're talking about the alleged victim.
Yes.
Okay. So she's now allowed access to information not previously permitted. But why is that a problem?
Well, because exactly for the reason that I said, it taints witness testimony. Even in civil trials, where maybe the worst possible thing that could happen is somebody could have to pay $50,000 damages or something like that. Witnesses will not be allowed to be in the courtroom watching other witnesses give evidence, looking at the defense or the evidentiary exhibits. They won't be allowed in the courtroom until after they have already given their testimony, because to see that evidence will taint even a normal, well-meaning person's testimony. And so what you just don't want to, and the complaining witness in a sexual assault trial is the most important witness. They're the primary witness. So you're essentially mandating now in Canada the tainting of the testimony of the primary witness in the case. And it's something that is not allowed in any other type of criminal trial, and certainly not even allowed in civil trials where the stakes are much, much lower.
Yeah, there's been a lot of criticism, though, in this country of the fact that, the alleged victim has little to no rights at all, and little to no protection, and very little looking after somebody who may have been through a really, really difficult ordeal and has had the courage to bring the case to court. Because, as we know from organisations like the Rape Crisis Network, a huge percentage of rapes never, ever actually even make it to court.
That's true. That's absolutely true. The idea of victim rights, like victims should have the right to counseling. They should have the right to an advocate who, sort of maybe helps them through the reporting and the courtroom process, the whole sort of criminal litigation process. Somebody to sort of hold their hand and bolster them and help them through it. But because it's a criminal trial and the client of the prosecutor is not the complaining witness, it is the people. This is why prosecutors have prosecutorial discretion. If it's not in the public interest to prosecute somebody, then they have the right to decline to prosecute, because the people is their client. The complainant is not their client. And so because the complainant, and it's unfortunate for the complainants, but complainants, because they are not a party to the case, they have no rights within the context of that criminal case. They are merely a witness. And I think that's one thing that most people don't understand, that any alleged victim of any crime is merely a witness to that crime, and will be treated as such in a courtroom, regardless of whether they're the witness, the victim of a brutal beating, or a burglary, or a robbery, or some other form of assault. They are only a witness. They have no rights within the context of a trial.
So do you feel that if we try to give more protections to alleged victims, that this could result in innocent men being convicted?
Oh, you're always going to have innocent men being convicted. I mean,
well, there's actually very few men convicted of rape, because most rape trials end in a not guilty verdict.
Well, I would really love to see the numbers on that. In Canada, the conviction rate for sexual assault is, after it's gone to trial, is something like 57%, which is actually that's only about 4% lower than the conviction rate for murder when murders go to trial. So you're sort of looking at, I think, a lot of people confuse the attrition rate for sexual assault, so the number of reports to police versus the number of convictions. That's not generally what we consider to be the conviction rate. The conviction rate is the number that actually get prosecuted that end in a conviction. And in most Western countries, I would have to double check the numbers that but I would expect that at least the majority of sexual assault cases that are prosecuted end in a conviction. You may get the impression that that's not the case because the acquittals to get a lot of news coverage because people are genuinely outraged if they feel that justice has been denied, and we really do want to think that a case wouldn't be brought into court if the accused was not guilty.
Okay,
so
well,
essentially,
yeah, it's an interesting one. It is an interesting one. We're going to have to take an ad break. We'll be back after these. We're chatting to Canadian men's activist Karen Straughan, who's speaking at the men's conference in Dublin this weekend. Karen, you mentioned the law around sexual assault has changed in Canada. We're looking at changing the laws here. It seems to be happening in a lot of countries. Can I just ask you briefly, has the whole #MeToo thing brought about all of this, and do you think it's gone too far in favour of women's rights against men's rights?
I do think that we're at the point where we're starting to encroach on tenets of the law, cornerstones of the law that took hundreds of years to establish, starting with the Magna Carta at Runnymede. So we're really beginning to dismantle all of the advances that we've made. That you have to understand, as somebody who I'm in love with the law, I really, really, it interests me. It makes me feel passionate about things. I get very, very into court cases. But when you actually look at the evolution of the law in terms of limiting the power of the state to interfere unjustly with people's lives, so to protect the individual from the immense power of the state. This is really what these due process protections for defendants, for the accused, that's why they exist. And they are there to protect everybody, because if you can dismantle due process protections and the presumption of innocence and shift the burden of proof, maybe lower the burden of proof for the state, make things easier to convict people of one type of crime, well, you're already looking at eroding it in terms of other types of crime. And you have to realize that in states where there is countries where there is no due process, where there is no burden of proof, where the law does not protect the individual the way it does in the Western countries, people get arrested when they have not committed any crime just because they're inconvenient to whoever's in power. And this is certainly not any place where I want to live. So I'm very, very, very protective of those advances in our jurisprudence, the advances in our legal system that began, again, with the Magna Carta and have steadily evolved since then. Things like having to read a suspect his rights before, when you arrest him, allow him to know that he doesn't have to answer questions. All of those things are there to protect the individual from the state, because we understand that the state can be a bad actor. Okay. We understand that the state can be an oppressor.
Well, we have to leave it there for this morning. But thank you for joining us on the program's Canadian men's activist Karen Straughan, and she'll be speaking at the men's conference at Wynn's Hotel in Dublin this weekend. Thank you, Karen.
Call Limerick today now on 46 19 95.
Can't you see it too? There's an elephant in the room.